Welcome back to the Daly Black podcast called The Brainstorm. We are here with the Dean of National Claims Institute, the producer of Listen to This Bull, and the president of All Good Adjustments Incorporated. We got Matt Mulholland here with us.
Hi.
Hi.
How are you?
Good. Good to see you, man. Thanks. Thanks for being on the show. Today we are here at, what is this convention called? Today we are here at the WIN conference, and what I really wanted to do today is I wanted to bring value to everybody here through stories. I feel like the best way to pick up on a lot of notable things that are happening in this industry and to paint a picture for people is to give a story. So kind of a quick couple questions is, do you have a claim that comes to mind, like a standout claim, standout case, something that you've seen in your career where it's like, that's something that really stood out and took the forefront?
Like, are you looking for like a, wow, man, I made so much money on that claim kind of a claim? Or one of those, oh my God, there is a shit ton of bullshit involved in this one?
Let's go with the latter. Let's do that. But if you want to share
bullshit,
let's do that one. But
I got a claim we can talk about.
Okay.
Hurricane Michael.
Okay.
On a home, and this home had steep shingled roofs and a built-up flat roof, gravel ballast built-up flat roof.
Okay.
And the flat roof was hit by a tree and then caved in.
Okay.
And into this, I'll call it a game room because it had a pool table in it, a billiards table, which became a true pool table when all that water was on top of it.
Yeah.
Maybe that's why they call it.
Maybe so.
Why don't they have pool tables that you can put inside a swimming pool?
That would be fantastic. I think I've seen something like that, but it's more like a ping pong type of deal. Something like that. But that's a good idea.
It's called a pool table.
It should be in a pool. I like that.
It makes sense.
Are you any good at pool?
I would be if I was in my swimming trunks.
Fair enough.
Because I gain confidence in those.
Oh, for sure. The shorter, the more
Instantly
confidence.
better.
Chest puffs out.
Anyway.
Very Paul Bunyan-esque. All right.
Paul Bunyan.
Yes.
I was talking to somebody about this. Anyway, water came down, obviously. Yeah. House ended up getting flooded. There was wind damage to the shingled roofs. And they had a mansard set of roofs, a very, very steep pitch, almost siding. Asphalt shingles almost uses siding.
Wow.
There was a slight pitch to it. It wasn't quite vertical.
Okay.
I got involved after the mitigation company had already been out there, and the carrier sent out Hancock, a ladder assist company, who got on the roof, and the insurance company paid for the flat roof that the tree hit, a right-hand slope, which was attached to that flat roof, and that's it. No spot repairs anywhere else. They said there was no other damage. When I got there, here's the real kicker of this entire claim. The equipment for the mitigation company was still in that game room.
Okay.
And if you know anything about water mitigation, mold remediation, you would have immediately had some concerns with the workmanship of this company.
Okay.
There were blowers pointing at visible mold.
No kidding. Blowing spores everywhere.
Thank you.
Yep.
Dehumidifier in the room wasn't on, but had it been, the drain line was going into a bucket on top of the pool tables. So it would have been draining right back into the same room.
Oh my God.
Yeah, that makes sense. The pool table was still in there, and it was more than it was before. It had grown some additional limbs, I think. It was pretty nasty. They didn't tear up all the carpet in the room. They left a small patch of it near the doorway, and then the doorway had a piece of plastic on it, but it was stapled about 4 times on the sides, and then a slit in the middle in order for you to be able to walk through, but no zipper.
Okay.
Nothing.
God.
So not really encapsulated.
Right, right.
And then on the roof, a blue tarp. So they're drying.
That is so ridiculous.
Now, we found out that the mitigation company was sent out by the insurance carrier.
Okay.
One of the unfair claim settlement practices is that the carrier has to have some processes in place to verify the workmanship of any insurance company owned contractor.
Okay.
The wording is weird on that. Insurance company owned contractor.
Right.
So I assume that means, and maybe there's some case law, I don't know, that means that if the insurance company hired the contractor, then the carrier owns that contractor, and then they have to have some kind of procedures in place to make sure that their workmanship is sound.
Such a weird wording. It's almost as if they're an agent for the insurance company.
Right. All slaves.
Absolutely.
Yeah. agent.
How did they phrase it? The carrier-owned contractor?
Carrier-owned contractor.
Wow, okay.
It is odd. I brought up to the carrier that there was additional damages on the rest of the roof and sent in photos. We brought up that the mitigation was not completed, that things were still wet, and that it had been done improperly, and that had now blown mold spores all over the home. And we sent out an industrial hygienist who confirmed that now there is mold all over the home.
Right.
And the carrier said that we were going to have to go after the liability insurance of the mitigation company because that wasn't their fault.
Okay. Where was the family during this the whole time?
Oh, they were still living there.
Okay. God.
Well, it was just a game room, right?
Sure, but
I mean, we could sit here and argue this particular policy language didn't have ALE kick in unless the home was no longer livable, or safe for occupation, that kind of stuff. But they definitely weren't maintaining their current standard of living, which was having a freaking game room.
Sure.
And they definitely were in a situation where there's mold in the house now, and they're living in that. So is it really livable? Somebody has to make that determination in order for that coverage to kick in.
Right.
The hairy part, there's three hairy parts of this claim.
Okay.
And a lot of it, the biggest stuff had to do with the mitigation. I'm going to stick to that in case this becomes a 1 hour long conversation.
Yeah, no worries at all.
We asked the insured who hired the mitigation company right after Hurricane Michael.
Yeah.
The homeowner did try to find their own mitigation company, but they were unsuccessful. They couldn't find anybody. So the adjuster, who was a very nice woman, offered to get one involved. Mm-hmm. And the insured said yes, please. So about a month later, because they were still busy as well, this mitigation company came out, started doing work, and then had the homeowner sign off on a work authorization form.
Okay.
No estimate was ever provided. No contract was ever signed other than a work authorization. It wasn't really a contract.
Right.
We never even saw the invoice from this company. The carrier paid them directly. So I asked the insured if she hired this company because the policy language involved in this was a farmer's smart plan.
Okay.
A very interesting policy, to say the least. It specified that the insurance company, our farmers, is not liable for the acts of any contractors that are hired by the insured directly. They knew to write out some issues.
Absolutely.
We asked the insurance company before I had to write the letter if they got the contractor involved.
Okay.
And the insurance company said no.
Okay.
Right. And then the homeowner said, I had her write that letter. The homeowner said that she couldn't find their own mitigation company. The carrier had to get their own involved, and that she never signed off on a contract. And in this letter, she stated that the insurance company refuses to admit that they hired the
mitigation company. Sure.
And she named the adjuster and said that she refuses to admit that she hired the so we sent that to the carrier, and then we got a call from that adjuster.
Okay. Who you preface was like a nicer individual. She was pleasant.
Honestly, she was doing what she could. A lot of field adjusters have this problem. Their hands are tied by their carrier's guidelines.
Yeah.
Policy might be a little bit over strict. There might not actually be enough coverage in it. Whatever it might be, most of the time they're doing their best.
Okay.
She ended up calling us, and I did tell her that we were on a recorded line.
Okay.
And she said, well, I'm glad I'm being recorded. I hope you play this for the policyholder. I did not say that she hired the contractor. I hired the contractor.
Okay.
I said, so you're saying that you with farmers hired the mitigation company, not the policyholder? She goes, yes, I never once said that the homeowner hired the contractor. We hired the contractor. She said, I hired the contractor.
That's the first time I've heard anybody from an insurance company like that take accountability like that.
And she was mad. I think she thought she was going to get in trouble.
Oh, okay.
Because she was named on that letter.
Sure. Do you know if she had been adjusting claims for long? Is it?
I can only speculate on that.
Go ahead. Yeah.
So we sent a copy of that recording to the insurance company to get them to pay for the mold throughout the house and to redo the mitigation and all that fun stuff.
Sure.
And the very next day, we got a letter from the carrier, her manager, I believe, that said she was mistaken. We did not hire the
You are kidding
carrier or the mitigation company. The insured did, and they provided a copy of the work authorization form, which, by the way, was never even provided to the policyholder.
No kidding.
They had her sign it digitally and never even sent her a copy. Carrier had a copy. Why would the carrier have a copy of that?
Right.
If the homeowner hired that contractor?
Right. Likely story. Right.
That makes sense.
What did they say the adjuster was doing? Daydreaming? Well, I mean, if she's that adamant about it, how could they possibly say that?
They simply said that she was mistaken.
Unreal.
Clearly, she was mistaken. Dude, she was irate. She wanted to she said this on the recording. Yeah. I want to set the record straight.
Damn.
Yeah, she was definitely very clear. There was no question.
Right.
She was not mistaken.
Yeah, that's not, I'm not sure, maybe it's a definite.
I want to set the record straight.
Yes. Yeah. Gosh. Okay.
It's still in litigation.
Right.
There's other issues along with it. We showed them wind damage. They said it wasn't. We sent them papers from engineers explaining how this kind of damage is definitely caused by wind. They said they disagreed. We asked them to meet us back out on site. They said no. There was a whole bunch of back and forth, but yeah, that was a very interesting claim.
It sounds like it. So my follow-up question for you is, after you have a situation like that, how did that impact you and your practice as a public adjuster? Did you take anything from that? Has your practice changed going forward? What did you in particular learn from that situation, if anything? Or did it solidify pre-existing thoughts?
It wasn't the first time I'd come across this, but let's pretend that it is, or I'll answer that question as if this was the first claim where I did have that problem. I learned a lot about how the unfair claim settlement practices works.
Okay.
The first time I came across an issue like this where there was a contractor involved that was hired by the carrier. Now, carrier vendors and the right to repair issue definitely muddy these kind of waters. So if it's a vendor sent out by the carrier, that's a carrier-owned contract.
Okay.
If the vendor sent out by the carrier is just referred, then there's going to be a contract involved. The vendor is going to have to provide a bid to the insured, not to the carrier.
Okay.
To the insured. Okay. If they don't provide a bid to the insured, what is the contract? That doesn't meet the four corners of the contract, right? What are the four corners?
So whatever is in the contract specifically, explicitly laid out in there.
Most of the time when we see a vendor get involved, all that they have them sign off on is a work authorization form.
Sure.
I don't think that's a contract because it doesn't stipulate what is coming from the policyholder and what is coming from that contractor in order to show that there is an exchange of services.
Right.
I don't think it's a valid contract. I don't think it meets the definition anyway.
Well, then you're bringing into the light and forefront consideration. Is there, that's the legal term, right?
That's the word I was
Is there consideration in here, which means a bargain for exchange, this for that, the quid pro quo? If one party is lacking what they need to be doing, is it a valid contract?
Right. And most of the time, if it's a vendor from the carrier, there's no assignment of benefits as provided, but then the carrier will pay that contractor directly. And even though that dollar amount is coming out of coverage A most of the time, it might be in coverage B, or it might even be content. So it could be a lot of different coverages. Even though that money is coming out of there, most of the time the policyholder doesn't know how much it is, ever.
Right.
And that's crazy.
Yeah, 100%.
So one of the cool things about the new law in Georgia that just got passed is the law says that any loss draft coming from the insurance claim has to have the policyholder's name on it. So if they're going to pay a vendor directly, it may have to have the policyholder's name on it as well. So in Georgia, we might actually have an improvement because of this law where now the insured will know how much of their coverage was extended towards a carrier's vendor. Now we have that managed repair issue, and the managed repair issue, I'm really surprised there isn't a lot of pushback on quality of workmanship.
Right.
Because the managed repair, they're definitely carrier-owned contractors.
Yes.
100%.
Yep.
If the carrier is liable for the contractor's work, depending on the state, they're liable for anything that occurs as a result of those repairs over a period of time. For most states, it's 3 years. Could be longer. If the work isn't done correctly, there's improper installation, negligent construction, and an ensuing loss occurs, not only would the carrier owe for the ensuing loss the policy probably provides, but they'd also owe to replace the improper installation or negligent construction stuff.
Got it.
Or you could just hire, even if it's a managed repair, policyholder has the right to know what's going on their property.
Sure.
They can hire a manager to oversee the work, their own foreman, that could still be covered by the policy. And if that foreman forces them to do the right job, probably will increase the cost of that job, and the insurance company is going to end up having to pay the full amount anyway. So anyway, these are things that I learned and uncovered and have applied to other claims as a result. But it's really interesting on who hires who.
I know. That's a crazy story.
Why would an insurance company ever want to be liable for the work of a third party?
Right.
Makes no sense.
None at all.
Why are they doing it?
Your guess is as good as mine.
I don't know.
Well, I mean, I think that the best way to learn, like I said, is through stories. I think that a lot of people out there could also take that approach and just really understand and digest these issues in way of a story. So I appreciate you coming on here and talking about that claim.
Sure.
And what you learned about it. Guys, Matt Mulholland, check out Listen to This Bull. Check out National Claims Institute. That's your new program that's been unrolling, right?
That's it.
That's exciting, man.
We'll have it fully open by the end of the year, but our first classes, our first courses are going to be offered mid-July. We don't actually know what courses we're going to offer right away first.
Okay.
We're still building the site out and the LMS system and all that fun stuff, but be aware it will exist. What we're doing is having a school for anything and everything first-party property claims related.
I love
train
it.
Contractors, public adjusters, insurance adjusters, even attorneys,
Yeah.
how to deal with first-party claims,
Right.
how to investigate, how to settle, anything and everything. And we're going to bring in a lot of experts to have a lot of certification programs that are going to be available there. This has a brick and mortar. This is we're in New Smyrna Beach.
Get out. That's awesome.
So it's going to be big.
I mean,
a lot of the stuff will be available online as well, but
yeah.
it's my full time. I am not getting much sleep.
I bet not.
we are-
That's awesome, dude.
But we're going to make this work out because it's so desperately needed, especially
really
on the
is.
public adjuster side of things.
And I want to check it out from an attorney perspective too. I'd like to be a part of that and just kind of see what
Yeah.
I can learn from that. I mean, like you said, it's needed. It's a
Oh, yeah.
tremendous amount of value you're providing. So major props to you.
Thank you.
Absolutely.
It's not all me, but thank you.
And then Matt Mulholland also, All Good Adjustments Incorporated. Check them out. Thanks, guys. See you in the
Thank
next
you.
one.